Yes, Mr. Dawson.
I'm obliged, my Lord. There are two things left that I want to address then concerning the opinion of the Inner House. The first is just to give the Court the references within the opinion of the Inner House in relation to state fault and the destruction of evidence as the Inner House saw it, and then finally to address some of the other errors of law for which I contend in the opinion of the Inner House. Now, dealing with the first of those then, the approach of the Inner House to the loss of evidence as an aspect of state fault, I've touched upon some of these paragraph references already, but just to give the Court the complete list now in this particular context. The first is to be found at page 157, paragraph 18, and it's the final, it's a letter B, sentence beginning, "In doing so." This is assessing the difficulty of enforcing a community right. The Court must clearly have regard to both the evidence that is available and the reasons for any apparent deficiencies in that evidence. And that exercise, as I say, was not carried out with a view to supporting a finding of state fault. There was then paragraph 37 on page MS 164 that we have looked at to some extent already. Just below letter F, an important reason for the taxpayer's failure to make a claim previously and to keep accounting or other records that would have supported such a claim will typically be national legislation preventing claims. That was the case in the United Kingdom. And then within the same paragraph, 5 lines from the end, there's a sentence beginning, "It may also be relevant to consider the explanation given for the non-availability of any direct evidence for the period in question. If that is the fault of the taxpayer, that may justify a strict approach to the primary evidence and a restriction on the extent to which inferences may be drawn from such evidence as is available." And looking at that general proposition, my submission is that to the extent the findings, in fact, made by the first tier bear upon the loss of evidence, they point to failings by the taxpayer rather than by the state or the tax authorities. By paragraph 55 of the Inner House's opinion at page MS 170, just below letter F, it was accepted that full accounting information was not available for the period in question. The primary reason for this was the historical nature of the claim, which was in large measure the result of the failure of the United Kingdom to implement properly the EU law right to reclaim input tax. It was also caused by the decisions made by the Scottish Office to centralise administration of VAT. So there's a running together of all the state fault arguments there as being the reason for the absence of primary records. Paragraph 56 I've taken the Court to already. That's about the destruction of records by the Commissioners. And then at paragraph 62 on page MS 172, between letters D and E, in connection with the absence of primary records and commenting upon the reasoning of the first-tier tribunal, the Court says, once again, this fails to address the fundamental problem that largely as a result of matters for which the United Kingdom government was responsible, such primary evidence did not exist for the claim period. And all of that, in my submission, is not supported by the findings actually made by the first-tier tribunal. And then finally on this particular issue at paragraph 64, still on the same page, in connection with the principle of effectiveness as a matter of EU law, on the third line, the Inner House says, this is a case where it is accepted that input tax was not claimed during the relevant period for reasons that are not the fault of the taxpayer, as to which I can only say that was not accepted, that it was for reasons that were not the fault of the taxpayer. What one sees, therefore, and the Court will see on a full examination of the analysis and reasoning of the First Division, is that at every turn what influences the approach is that this is seen as a case where, due to state fault, there is an absence of primary documentation. And for the reasons I've given in my submission, that was unsound. There are then a handful of additional errors of law that, in conclusion, I would wish to draw to the Court's attention. The first is that there are repeated references throughout the Inner House's opinion to the taxpayer's Fleming claim being one for the recovery of tax overpaid in breach of community law. Paragraphs 1, 5 and 6 are examples of that. For the reasons I've submitted to the Court already, this is not such a claim. I've mentioned to the Court already the approach one sees at paragraph 39 on page MS 165, where the Court emphasises that, in its estimation, the Tribunal's task in cases such as the present is merely one of quantification. It is not the establishment of the right to repayment of input tax. It is a matter of agreement that a right exists. Now, one has to understand what agreement there is as to the right to repayment. It is a right that arises under EU law and domestic law, but for all the reasons I've advanced before this Court, the establishment of that right and the enforcement of it depends upon satisfaction of the substantive conditions, and it's not accepted that the taxpayer has ever established the necessary parts of that right. But it's also an error in my submission, consequently, to treat the task as merely one of quantification. For all the reasons I've given, the quantification and the apportionment is a substantive and inherent part of the right. Next, at paragraphs 47 to 48 on page MS 168, the First Division discusses the role of the first-tier tribunal. It endorses what one might characterise as the conventional view set out, for example, by the Court of Justice in Van Schindel and of Lord Tyre in the Upper Tribunal, that the tribunal has a passive role, doesn't operate as a detective, and Lord Tyre's observation that the claim may be refused if the tribunal is unable to find on a balance of probabilities that any sum, even a minimum, can be ascertained as having been paid and not recovered. Having accepted that, though, one sees at paragraph 66, when the Court went on to answer the specific questions posed by the appellant taxpayer before the First Division at page MS 173. Letter E, so paragraph 66, letter E, the Court says, ultimately the difficulties of proof are not sufficient to reject the possibility of quantification, which cannot be reconciled in my submission with an acceptance that such a claim can be refused if the taxpayer has failed to prove the claim on the balance of probabilities. At paragraphs 87 to 88, in answering, so this is set out, I should say, at paragraphs 87 to 88 of the Commissioner's case at page MS 89 to 90, we address the proposition that appears in the opinion of the First Division that in cases of this sort, proof on the balance of probabilities should be understood as meaning, at a general level, is the taxpayer's contention more likely to be correct than the contention of the Commissioners? And for the reasons we've set out in the written case, my submission is that that's wrong. Proof on the balance of probabilities requires the person who bears the burden of proof to prove his case. And it's not a competition between the competing positions of the parties.
It was never HMRC's position that there had been no input tax paid. It was their position that it hadn't been proved how much there was, and hence that there wasn't a valid claim for it.
No valid claim at all for that reason?
Yes.
Correct. But for the reasons we've set out in our written case, with reference to well-known authorities such as the POP AM, our submission is that it's not a choice between the positions of the parties. It's the party bearing the burden of proof must discharge it. The final error of law, which at this stage I refer to in my submissions, is addressed at paragraph 92 of my written case. That's where there is an analysis of the 5 reasons the tribunal gave for rejecting the extrapolation exercise which the taxpayer had put forward. And this is the point I mentioned earlier this morning, that the findings that there hadn't been a change in certain respects during the claim period was nothing to the point, as the tribunal correctly found, because what it was being asked to do was apply data from 2006 to 1974 to 97. So the absence of change between 1974 and 97 was nothing to the point so far as that extrapolation was concerned. So for all those reasons, my submission is there are numerous and significant errors of law within the opinion of the Inner House, both as to the substantive issues concerning the right to deduction are concerned, and also so far as the established scope of appellate jurisdiction is concerned. So in conclusion, for the reasons I've set out in writing and in submissions this morning, the right to deduct does not exist in the abstract. It's a right to deduct a definite amount of VAT due or paid, including where required an apportionment. These are substantive requirements of both EU law and domestic law. Article 178, as my Lord and the Chair raised with me this morning, and Regulation 29, subparagraph 2 of the VAT regulations, certainly do provide that in the ordinary case it's a substantive requirement of both EU law and domestic law that invoices be available to support a claim for deduction. The reason for not placing weight on that in these proceedings is that of course, was not the approach taken by the Commissioners. The Commissioners looked at all the evidence which was available, but that would be the general position. State fault, for the reasons I've just touched upon lately in my submission, has no proper place in relation to this appeal. It wasn't argued and there are no findings to support it. It is in any event based upon a misunderstanding of the domestic provisions regarding the right to deduct. The principle of effectiveness in this case adds nothing to the discussion in my submission. And then ultimately, even quite apart from the substantive VAT issues that arise on the ordinary principles of appellate jurisdiction, all of the matters were considered by the first tier. The decision it reached was one it was entitled to reach. The upper tribunal properly recognised the limits of its jurisdiction, and in my submission, the First Division had no proper basis for interfering. So, my Lords and Lady, for all those reasons, I invite the Court to allow the appeal as indicated at the outset of my submissions.
Thank you very much, Mr. Thompson. Mrs. Sutherland.
My Lords, my Lady, this appeal marks the culmination of a course of legal development which began with the judgment of Mr. Justice Neuberger, as he then was, in the University of Sussex case in 2021. That chain of development has reached its climax in this case. In our submission, the commissioners in this appeal are seeking to frustrate or defeat the exercise of the right of recovery explained by Mr. Justice Neuberger in that case and eventually recognised by Parliament. I will address the Court on the following matters. First, the recovery of overpaid VAT in EU and UK law. Secondly, the incompatibility of UK law with EU law and its remedy. Thirdly, the evidence before the tribunal. Mr. Edwards will then make submissions on, fourthly, the role of the effectiveness principle and state fault. I will then make submissions on the role of the tribunal and why the Court of Session was correct to set aside the decision of the first-tier tribunal in this case. First, though, I will deal with 2 points which my learned friend raised. My learned friend said, the right of repayment doesn't exist in the abstract. It has to be a calculated figure. The right only exists in respect of a definite amount. And as he pointed out, these are substantive requirements of the law, and apportionment in VAT terms is equally a substantive requirement. So that is all correct, and we do have a definite amount. In this case, it's £929,874.69p, and that is at page 575 of the core bundle, where there is an exact one-page summary of what the claim is and how it is made up. Now, these are not figures carved on tablets of stone. As my learned friend says, like all figures in VAT, they're calculated figures. And indeed, the tax system is driven by inexact numbers. Think of calculating the lifetime allowance charge for pension purposes. But the fact that figures are necessarily inexact doesn't mean that they aren't real figures. Think of filling in a VAT return. You put your outputs in box 1, you put your inputs in box 4, and you press a button on your computer, and it comes up with calculated figure. Behind the box 1 figure and the box 4 figure, there is always a calculation, and rule 1 of VAT inspections is check the calculation of the box 1 figure and check the calculation of the box 4 figure. The need for calculation is all the more the case when we're dealing, as we so often are in VAT, with partial exemption, which is by definition of a proportionate figure. Look at bad debt relief for VAT. There are 3 ways businesses do it. You can do it on a invoice by invoice basis. You can do it on a percentage basis, where your accountants tell you what your annual percentage of bad debts is likely to be. Or you can do it on a percentage basis and then have an annual correction by reference as far as possible to actual experience. All are equally correct. The test is, and this is set out in the Commissioner's, very sensibly set out, in the Commissioner's Fleming guidance at paragraph 2.6, which is at page 1481, and it says the only test is that estimates should be reasonable and sustainable. Reasonable and sustainable are the lodestar of this exercise. And of course, there are good calculations and less good calculations. That is what people spend a lot of time and energy analysing, the relative merits of calculations and whether they stand up as being reasonable and sustainable. And the point which the commissioners don't really address, though my learned friend touched on it briefly at the end, is that the problems which taxpayers have faced in this area do derive to a significant extent from the failure of UK legislation to clearly establish the right and modalities of the right to recover overpaid VAT. And this was exactly the point which, again, my learned friend referred to at the end, which Lord Drummond-Young was making in paragraph 38.
By overpaid VAT here you mean input tax deduction?
I was going to go on to that.
Okay.
We would say there's no distinction between overpaid output tax and under-recovered input tax. That's inherent in the system. That was the second point I was going to refer to of the points my learned friend had raised. And the difficulties for the taxpayer in making his calculation can arise equally in both areas, but it's more difficult in relation to input tax because of these difficulties of apportionment. But these are inherent in the system. There's nothing new in these. And this is exactly what Lord Drummond-Young was saying in paragraph 36, which, as I say, is at paragraph 1 on page 1481. Oh, 38, I do beg your pardon. Nevertheless, we think it important to bear in mind that in historical Fleming claims, the responsibility for failure to make the claims when full evidence was still available lies in considerable measure with the state. In legislation that did not conform with EU law right to recover input tax, and in the case of the United Kingdom, in the convoluted attempts to impose limits, to impose time limits in historical terms.
But I think it's being put against you that, in fact, UK law at the relevant time did allow you to recover input tax and therefore conformed.
We would dispute that, and I will come back to that point later, my lord, if I may.
Right.
My lord, Lord Legate, made the point that you don't bend the rules of evidence because you're claiming late. That is self-evidently, with respect, absolutely correct. But the way you apply the standard must be varied according to the circumstances of individual cases. Think of classifying law degrees in university exams, when you've got to put papers into first class, upper second, lower second. You can have two papers in the same class which can meet the same standard but meet it in a completely different way. And again, one of the points that the Inner House was making is that you have to apply these same evidential standards, taking account of the historical and factual circumstances in which they fall to apply. Now, the second point of the preliminary points which my learned friend raised was that it was suggested that there was a difference, and my Lady Rose has just made the point, that there was a difference between claims to recover overpaid output tax and claims to recover input tax which should have been deducted earlier. And because San Giorgio and other cases are concerned with tax which was levied in error, not which tax which should have been reclaimed earlier, they are not of such significance in this area.
Well, it goes further because Mr. Thompson disputes that it should have been reclaimed earlier. He says there's no obligation to reclaim.
There is
It's just a voluntary choice whether you do or not.
Yes, but then Parliament has given us a statutory right in 2008 to do that. So one cannot be criticised for exercising a statutory right. Why one didn't do it earlier, that is a long story, and that we can come back to later. The point is that overpaid output tax and under-recovered input tax both embody that anathema of the VAT system, hidden or concealed or embedded VAT, which is system distortive because it results in consumers paying VAT at a rate in excess of that prescribed by the law. And the shortcomings in the UK legislation were not, as my learned friend suggested at one stage, minor or inadvertent. For that, we need to go to the judgment of Lord Hope in the Fleming case at paragraph 10 on page 1649, where Lord Hope said, there is a gap in the legislation which is unfulfilled, which is unfilled. The infringement of EU law in this respect cannot be said to have been comparatively minor or inadvertent.
What's the infringement? Isn't he talking about infringement of legal certainty in relation to time limits? Or is he talking about the VAT rights to reclaim input tax?
What he was talking about there was the fact that the law prevented you from making a recovery for under-recovered input tax by the imposition of the time limits without any transitional period.
Right.
I mean,
So
if we go to...
You can't treat this as saying that there was a failure to implement the right to recover it at all. It was just the wrong imposition of a time limit when previously there'd been no time limit for certain years.
This, as I say, I can go to this point now, my lord, if that would help the court.
Well, whenever
Up to
when you do,
1980.
but it seems to me the crux of the case, really.
Yes, yes. Well, let's go on to that then straight away. Up to 1989, there was no formal provision in the UK law to recover overpaid VAT, whether it was overpaid output tax or under-recovered input tax. In the area of direct taxes, there was a statutory remedy for mistake, but that was fairly limited. And alongside that, there was a right under English law. I don't know what the position in Scottish law was, but there was a right in English law to bring an action against the tax authority for money had and received. And the Crown would have to decide whether to defend such an action, and they would normally defend such an action successfully on the basis that the overpayment of tax was due to a mistake of law. Now, that position, as far as VAT was concerned, that position changed in 1989. What happened in 1989...
Well, sorry, just before we go on to that, I follow that in relation to overpaid output tax, but how does that work in relation to unclaimed and hence unrecovered input tax?
What happened in relation to underclaimed input tax was that people hardly ever made a claim in this regard. People simply weren't, the familiarity with administering VAT only took time. It was only introduced in 1973.
But you referred at the outset to, box one, and even I vaguely remember filling in my VAT returns 100 years ago when I was a barrister, and you used to fill in your income, and then you used to put in a box your inputs, and they were deducted, and you paid the balance in VAT.
Exactly right.
People
exactly
did that
right, my
from
lady.
the beginning.
But the question then arose, what happened in a subsequent prescribed accounting period if you found that you had made a mistake in an earlier accounting period?
Southern, we must be cautious relying upon our memories of filling in VAT forms, but I seem to recall that box 5 was under declarations not made in previous accounting periods.
Ah.
But maybe that only came in 1989.
Well,
I rather doubt it. I'm feeling somebody else was doing my return.
If I may say so, my lord, you are well ahead of me. That came in exactly in 1989.
Maybe.
But there was never anything stopping people from, and in fact people did, deduct their input tax from their output tax on their VAT return.
Indeed, but the problem was, as my lord has anticipated, the question of making adjustments to earlier returns in a subsequent return.
But in this case, there was no accidental or mistaken failure to deduct input tax. It was a deliberate decision.
No, that is quite right. It was simply, one is in danger of speculation, but something of the background of this was explored in the University of Sussex case, when the court will recall, it was found that the University of Sussex hadn't reclaimed a penny of the input tax it was entitled to recover for 23 years. And certainly the public sector, and to a lesser extent the private sector, was simply not familiar with the procedures for recording and recovering input tax, which became second nature.
But we've been told in this case that so far as the health service in Scotland was concerned, it was a matter of deliberate policy as part of the way the public sector was administered in Scotland, that input tax was not claimed.
That is exactly right, my lord, yes. And it was a matter of deliberate policy of the University of Sussex not to reclaim input tax until they changed their policy.
And I mean, nobody was necessarily any worse off because of that. It just meant that the revenue received money which they might not otherwise have received, and the health service paid out of its budget money which it might otherwise have retained, but no doubt that was all taken into account.
That was certainly what the Treasury always argued, but people ceased to believe them after a time. But in a way, these are political and constitutional changes which were a matter for political scientists and historians of the changing nature of the state, of relations between different organs of the state. And one could discuss that a long time, and it certainly provides the background to a case like this, but it doesn't provide the solution, which is what this court is concerned with.
But it does mean that we have to bear in mind it's a completely different situation from the type of situation that arose in the FAI test claimants case that was cited, or San Giorgio, in cases where there was actually a failure to implement EU law in domestic law, and in consequence of that failure, people overpaid, were compelled to overpay the tax that was properly due.
That is absolutely right. But then we also, if we're casting back our memories, we have to recall the novelty of VAT, that when VAT was introduced in 1973, it was almost uniquely amongst UK taxes a self-assessed tax. I say almost uniquely because I think estate duty would have counted as a self-assessed tax, because it had to be assessed by the executors or personal representatives. But it was a novelty when VAT was introduced on the 1st of April 1973, that it was a self-assessed tax. In the good old days, you sent off your, sorry, this is direct taxes, so we won't refer to that. The taxpayer had to compute his own assessment to tax. At the same time, making his self-assessment, he had to account to the tax authority for the tax so assessed. And from 1973 up to 1989, there was no formal mechanism for recovering overpaid output tax or under-recovered input tax. I think that is the first point that my Lord Legate was concerned with.
That's one point, yes.
Yep. That changed in 1989, as my Lord Briggs has already anticipated.
Well,
that was the case.
I think you answered my question by suggesting it was not.
But the reason for it is another story.
Yes.
Now, this is not a case in your authorities, but we could easily cover it. In Fine Art Developments and the Customs and Excise Commissioners, which is 1989, Simon's tax case is 85, it was established that earlier over-declarations or under-declarations of VAT could be corrected by the taxpayer through making a box 4 entry in subsequent returns. Fine Art Developments found that it was paid, it had overpaid VAT by £1 million. The commissioners wouldn't repay this amount, so it resorted to self-help and simply put a deduction of £1 million in its box 4, and the commissioners disputed this deduction. And the House of Lords, in a very brief judgment of Lord Keith, said that there was nothing in the legislation to prevent this being done. So in that case, they were able to correct a previous overpayment of VAT by making an adjustment in their current year return, in their return for the prescribed accounting period. That led to Finance Act 1989, Section 26, which I think is at page 1257 of the bundle. The commissioner said, well, look, it's just we've got to formalise arrangements. FA 1999, what I have a fear is it's Section 24 you've got, not Section 26. It is. But again, that can be put right. That can be put right. What Section 26 FA 1989 said, well, it introduced specific provisions to regulate the recovery of overpaid output tax. The right to recover arose regardless of how the overpayment arose. So all the old problems about was this a mistake of law or was this a mistake of fact, which bedeviled these claims for money hadn't received, that one didn't need to worry about. There were two rules contain the new rules contain two restrictions on the exercise of the Section 26 rights. Firstly, there was a 6-year time limit. The time limit was set at 6 years from the date of payment. And secondly, a passing on defence for the tax authorities where the extra costs had been passed on to customers so that repayment of VAT would unjustly enrich the claimant so that he'd receive an unmeritorious windfall.
If you'll excuse me interrupting, I think actually Section 24 is the correct section.
Then my memory, 2, my notes are deficient. I'm relieved you have the correct section.
Section 24 is about recovery of tax which wasn't due, a VAT which wasn't due. And it does have an unjust enrichment defence to the revenue, and it does have a 6-year time limit.
Yeah, and the extension, well, there's been a mistake.
Right.
But I don't know whether there was a separate section to deal with unclaimed output tax.
Yeah, because if you didn't make your claim for the input tax, it is tax which is due, and therefore this wouldn't apply.
Well, that is precisely the point Lord Newburger came to in University of Sussex.
Are you saying everyone thought that this applied, and it was only when Mr. Justice Newburger actually brought his mind to bear on it, he realised that actually the wording of it didn't apply?
Or was there a Section 26 which deals?
I don't think so.
No.
I think it's like everyone thought Section 80.
I mean, the problem was the subsequent introduction of the shortened limitation period in the 1997 Act, which was brought in with retrospective effect.
No, I have happily brought my Butterworth's Orange Tax Handbook for 1991 to 92 with me, and that confirms, yes, it's section 24.
Right, oh, it is, okay.
Where a person has paid an amount to the commissioners by way of value-added tax, which was not tax due to them, they shall be liable to repay the amount to him. Commissioners, and then there's the two restrictions. So yes, it is section 24, as we said. But at the same time...
I'm so sorry to take up time on this, but are you saying section 24(1) does have some application where the taxpayer has simply failed to make a claim to deduct input tax?
The point my Lady Rose has made is that at that time, and up to the University of Sussex case, it was thought that the rules for the recovery of overpaid output tax also covered under-recovered input tax, because under-recovered input tax went into the calculation of VAT due to the commissioners, and so it was simply an aspect of payment of output tax. Right. And that the commissioners argued for 10 years. I mean, perhaps we need to go on to the University of Sussex case when we've dealt with this point.
Yes, so the commissioners argued section 24(1) did cover when you paid too much tax because you had failed to deduct your inputs.
Yes.
And the commissioners wanted that to be the case because that imposed the 6-year time limit, whereas if section 24(1) didn't cover it, there was no time limit, which is what, in fact, Mr. Justice Neuberger decided.
My Lady Rose states the position far more clearly and accurately than I could possibly do. The choice of the 6-year time limit was because this was also the period for which tax records had to be retained. So a taxpayer making a claim to recover overpaid output tax would, by definition, be required to have the detailed records to explain the basis for the claim. And as my Lady Rose has explained, input tax recovery being an aspect of the payment of output tax, the time limit was also assumed to apply for input tax recovery claims. And at the same time, as my Lord Briggs has explained, the form of the VAT return was modified, and the VAT regulations were also modified to make it clear that you could correct earlier underpayments or over-recoveries through an adjustment to a subsequent return, but regulations governed when corrections could be made through the return and when corrections had to be made or claims had to be made outside the return. And if it was a case where the correction or adjustment couldn't be made through the return, it had to be made by a separate application to the commissioners, which was then called a voluntary declaration and is now known as an error correction notification. And this equally applied if the taxpayer owed money to the Crown or the Crown owed money to the taxpayer. So, Finance Act 1989, Section 24 became Section 80 of the Value Added Tax Act 1994, which is at page 1402. And after the 1994 VAT Act had replaced the 1983 VAT Act with effect from the 1st of September 1994, the 1995 regulations replaced the 1982 regulations with effect from the 20th of October 1995. Now, claims made under Value Added Tax Act 1994, Section 80, were made outside returns by means of voluntary disclosure, as I've just mentioned, now called error correction notifications. But it remained, or it was formerly the case after 1989, post Fine Art Development Number 1, that certain corrections, as specified in regulations, could be made in the return. And nowadays, of course, we've got two methods of making corrections to an earlier return in a subsequent return, known as Method 1 and Method 2. Now, then I think probably we can go, if I'm not taking things too much out of order, onto the University of Sussex case, if that makes sense to the court. UK law chose to make separate provision for output tax and input tax. The payment and recovery of output tax is dealt with by primary legislation, and the payment of input tax is regulated by statutory instrument. And the reason for this approach was that accounting for input tax was regarded as simply an adjunct to and an aspect of the payment of output tax. Input tax recovery was simply a deduction from output tax payable. Historically, under-deducted input tax was regarded as a form of overpaid output tax, and the regulations were simply a gloss on the rules in the primary legislation.
But it wasn't I mean, you could make a claim, a positive claim, for repayment of output tax if it exceeded, of input tax if it exceeded your output tax, couldn't you?
Yes.
I seem to recall that young barristers were always encouraged to register for VAT before they had to, for that very reason.
Yes, and equally they were
before they got their fees.
Yes, indeed. Equally, my lord, they were encouraged to register for VAT even when their turnover was way below the threshold, because it was thought they would be more prosperous.
Make an input tax positive claim.
Yes, hence the carousel frauds depended on that.
I don't think we need go that way today, my lord. But yes, that is exactly the point. But
my question to you is, you're putting as if accounting for input tax is just a sort of adjunct to accounting for and paying output tax, but sometimes it led to the revenue having to pay you a positive sum of money.
Indeed, my lord. This was quite wrong. This is what Lord Neuberger established. But this was one of the reasons for the unsatisfactory state of the legislation. Yes, of course it makes, and of course it's a nonsense when you apply it to repayment traders like Tesco's, who have vast monthly recoveries of VAT. Now, going back to 1989, the government was concerned that this 6-year time limit was overgenerous. And on the 18th of July 1996, HM Paymaster General announced the immediate imposition of a 3-year cap on claims for overpaid VAT and other indirect taxes. And on the 4th of December 1996, the House of Commons passed a budget resolution under the Provisional Collection of Taxes Act 1968, giving provisional statutory effect to the new rule. This was duly enacted in Finance Act 1997, Section 47, which substituted in Value Added Tax Act Section 80 a time limit of 3 years. So, Finance Act 1997, Section 47, subsection 2, provided that this change was, and this is, sorry, at page 1454 of the bundle, deemed to have come into force on the 18th of July 1996 as a provision applying for the purposes of making any repayment on or after that date to all claims under Section 80 Value Added Tax Act, including claims made before that date and claims relating to payments made before that date. So the new rules on output tax applied both retrospectively and prospectively. The corresponding amendment to Regulation 29 of the VAT regulations only came into force on the 1st of May 1997. Regulation 29(1)A was inserted into the VAT regulations with effect from the 1st of May 1997, and this provided the commissioners shall not allow or direct a person to make any claim for deduction of input tax in terms that such deduction would fall to be claimed more than 3 years after the date by which the return for the prescribed accounting period in which the VAT became chargeable is required to be made.
Could you give us the electronic bundle reference for that?
It please? Is at 1446.
Thank you.
But I have a suspicion that that is the modern form rather than the pre-amendment form or having the regulation.
Yes,
yes.
It's the current version.
I mean, perhaps we need to produce to the court the 1995, sorry, the 1997 and the 1998 version of the regulations, just to show that change. I do apologise, my lord. So, as we said, these changes to Regulation 29 were introduced by subordinate legislation, so there could be no express retrospection, that being outside the vires of the enabling provision. However, just as it was thought that an input tax recovery time limit had followed on the coattails of output tax recovery time limit of 6 years when it was introduced in 1989, so the reduction of the latter from 6 to 3 years would automatically apply to output tax and input tax alike, both prospectively and retrospectively.
Sorry, could you say that again?
Yes. Because
the changes made to the Regulation 29 were made by secondary legislation, so they weren't retrospective because that would have been ultra-vires.
Outside the vires,
but you're saying that the same result was achieved by some other...
It was assumed that because input tax recovery was simply an aspect of output tax recovery, there'd be an automatic read-over of the The 6-year time limit applied to input tax recovery from 1989.
Because of the change
when it was
made to Section 80.
It would be automatically read over from Section 80, precisely, my lady.
Because it was still thought that Section 80, like it had been thought that Section 24 covered the recovery of underclaimed input tax as well as actually overimposed output tax.
Yes, that is it in a nutshell, my lady.
When you say it was thought, it was assumed, do you mean that was the position that the commissioners took?
Yes. I mean, the three most dangerous words in law, or the two most dangerous words in law, I assumed.
Obviously, many people did, but ultimately, some who didn't proved to be right. But that was the commissioner's position, which is...
That was the commissioner's position,
yeah.
And that was the one that was tested in University of Sussex,
Yeah.
which we now come to. As I say, on to this apparently unclouded scene, the University of Sussex appeared. On the 25th of November 1996, the University of Sussex made a claim for repayment of input tax covering a period of 23 years from the 1st of August 1973 to the 31st of July 1996. The university had become registered for VAT on the 1st of April 1973, but had not thereafter, until October 1996, sought to set its input tax against its output tax. The commissioners argued that under-recovery of input tax gave rise to an overpayment of output tax. So all claims up to the 1st of May 1993 were out of time by reason of the 3-year time limit for such claims in Value Added Tax Act 1994, Section 80, subsection 4, as amended by Finance Act 1997, Section 47. And as we've just said, this had been introduced with effect from 18th of July 1996, and the claim was only made on the 26th of November, or 25th of November 1996. Now, the VAT and Duties Tribunal had little difficulty in rejecting the claim on the same basis. But the university argued that Section 80 was only concerned with overpayments of output tax and not underclaimed input tax. Accordingly, Section 80 and the time limit which it contained had no application. As regards Regulation 29, paragraph 1A, this only came into force on the 1st of May 1997, and being in subordinate legislation, could not apply to claims which had been made before that date. And the judgment is at 1955 in the bundle, and Mr. Justice Neuberger decided, in the context of Article 18 of the 6th Directive, that the right to recover output tax under Section 80 is distinct and separate from the right to recover input tax under Regulation 29. The right to deduct input tax in respect of any period arises only when the claim is made, whether through the correction of the return or by means of a voluntary declaration. And that's at paragraph 63 of the judgment.
Is that 1995?
That is at... Sorry, I haven't written that one down, which I should
be
have
1969,
done.
we've taken to before.
It's paragraph 63 of the judgment, which begins at 1955.
1955.
It's page 1971.
I'm very grateful, my lord. I mean, accordingly, there was no automatic carry across of the Section 80 time limits to output tax claims, for output tax claims to Regulation 29 input tax claims. In short, claims to the repayment by the commissioners of input tax that could have been made but had not been claimed by the taxpayer in an earlier accounting period could only be made under Regulation 29(1) of the VAT regulations, not under Section 80, subsection 1 of the Value Added Tax Act. Claims under Section 80, subsection 1, were subject to a 6-year time limit, but claims under Regulation 29 were not subject to any time limit. This situation arose because for 10 years the tax authority had incorrectly argued that the same legal provisions which governed the repayment of overpaid output tax also governed the recovery of input tax. This was a surprising and perhaps unintended result. The commissioners appealed to the Court of Appeal. When the Court of Appeal dismissed that appeal, the commissioners did not seek leave to appeal to the House of Lords. This was because it so appeared, that while there was no time limit in place which applied to late claims to recover input tax made before the 1st of May 1997, for claims made after the 1st of May 1997, the 3-year cap introduced by the new Regulation 29(1)A applied. However, the commissioners had built on sand rather than on rock. Now, that has rather taken me out of the way from what I was going to say earlier, so I can carry on from there, or I can go back to the beginning, where the next stage is going to be the impact of the Marks and Spencer's case, followed by Fleming, followed by Section 121. Let me think. Perhaps, if the court will allow me, I will. Let me just.
Can I just ask where we're, just to understand where we're going with the argument? Fleming tells us that the retrospective aspect of Section 80 was unlawful under EU law, and we then have the new provision which introduces the transitional provisions. But as you've just explained, so far as input tax is concerned, we're not within the ambit of Section 80 at all. So Do we need to look at Fleming and its aftermath?
I think we do. I will try and do. Let me just outline what our case is in general, because I've run rather ahead of myself.
Yes.
And then, aware of the time, just to look briefly at Marks and Spencer's and Fleming leading up to section 121.
Yeah.
Because at the end, 121 is central to this case, because this was actually a claim under section 121 of the Finance Act 2008.
Mr. Southern, just before you go down that route, just so that I can get my mind clear, is there a provision in EU law that says if you don't claim to deduct input tax at the relevant time, that you have a right to make a late claim for recovery of input tax?
No, there's nothing in EU law to that effect. But what it says is that procedural rules, which include limitation rules, which are for this purpose are classified as procedural rules, not substantive rules, that procedural rules are within the province of the member state. They're outside the scope of the treaties, provided that the domestic law procedural rules conform with the general principles of EU law, which include, as my learned friend has explained, the effectiveness principle and the proportionality principle.
So is this right, that the UK gets into difficulties because it has, although not obliged to do so, included in domestic law a right to make late claims for recovery of input tax, and it has done so without or without a limitation period, as was found out in University of Sussex, and then there's a problem where they try to introduce limitation periods on that later on?
The question would be the right to recover overpaid output tax and the right to recover underclaimed input tax have been held in subsequent cases to be directly effective EU law rights. So, up to 31st of December 2021, the UK could not have as such prohibited the recovery of overpaid output tax or under-recovered input tax, because those would have been directly effective EU law rights which the UK courts were obliged to enforce.
I can see that the right to recover input tax is a directly effective right, but I think you just said that the right to recover unclaimed input tax, impliedly at some later time, is also a directly effective right. But that seems to conflict with what you said in answer to my Lord Sales's previous question, which was that there was no such right under EU law to make a late claim. I can quite see, as I say, that the right to recover input tax is a directly effective right. The question is...
That, I think, was held in Fleming to be, or recognised to be, a directly effective EU law right. Though your ladyship is entirely correct that I think before then there would have been some doubt on that issue. Is that right? What my learned friend says or suggests is that, and I suppose this is why it was less clear before the Fleming case, is that obviously the general rule for VAT is that you have to reclaim your input tax in the period in which it's incurred. But then it was Article 18.4 of the 6th Directive, I think now Article 180 of the Principal VAT Directive, says that member states may provide alternative ways of making the deduction. And that will include making later claims to recover input tax which should have been incurred, which should have been reclaimed earlier. And what my learned friend suggests is that this would have been covered by your San Giorgio remedies, the right to recover under-recovered input tax at a subsequent date, either by return or by voluntary declaration. I hope that's a sufficient answer for...
It's very unclear, because if it says, to me, if it says it may provide alternative ways, that suggests that there is no right under EU law. It's up to the member state whether it chooses to provide alternative ways or it doesn't.
Yes. Well, I think I've got to say yes, no, my lord.
No, well.
Because while, as you say, the directive says may, that has been read as meaning shall, because otherwise you're trying to keep people out of their EU law rights. But also, it is clear that if a state does introduce such a right, then that has got to conform to San Giorgio effectiveness principle, proportionality principles. And that, if not elsewhere, was laid down in the Telios case at para 45 of the ECJ's judgment.
Yes, so that, as you said, that there is a right to recover input tax in the period for which it is incurred. That's a directly effective right. Then, as to the content of that right in each particular member state, then you have to look at the principles of effectiveness and equivalence and look at how late you can claim back direct tax underpayments or whatever. And if the rules are more onerous for VAT than there are for other taxes, or if they are unduly onerous, that may, by supplementing the basic directly effective right, in fact impose an obligation on the member state to allow some late claims. Is that fair?
We would respectfully agree with that exposition of the law, my lady.
But presumably it's not contrary to EU law to have a time limit of 3 years, no, provided you don't introduce it backdated.
Precisely. Yep. Yes, indeed. So simple, but there we are.
Yes, where you've got us thus far, if you're right, Mr. Southern, is that there never was any infringement by the UK of EU law in how it dealt with claims to late claims to recover input tax.
Not until it started introducing rules. And as I say, those rules were introduced in 1989, both in the form of a formal procedure for recovering overpaid output tax, which was thought to recover under-recovered input tax, which could be made, as we've said, either through the return, yes, or
but in
by
the light of,
a separate
in the light of the University of Sussex case, which separates the two claims out, at least at the theoretical level, yes, they may lead to the same result.
There was this period then from 1989 to 2001 when it was assumed that the two
when the revenue commissioners were misapplying the law.
Precisely, yes. Or not understanding the law.
I thought, I stand to be corrected, but I thought that, whereas you've told us that when the new Regulation 29(1)A came in, imposing a 3-year limitation period with effect from the 1st of May 1997, that wasn't retrospective, but I thought the problem identified in Fleming and Bodycraft was that it was retrospective, and that was why there was a breach of EU law found in that case.
Well, it was certainly thought by the commissioners to be retrospective because they saw it as hanging on the coattails of the new limitation period for output tax claims.
Yes, well, no doubt we'll come to it. I thought the House of Lords accepted that. But I'm just speaking from recollection of having, when I last read the case.
We'll come to those cases later. I was just going to say something about, I mean, as the court, perhaps I might just say a little about our particular case on this claim. As the court's clearly aware, this appeal arises from a Fleming claim for recovery of input tax incurred for business purposes by the 44 laboratories maintained by the NHS Lothian Health Board in the claim period. And the claim period runs from the 1st of April 1974 to the 30th of April 1997. The repayment claim is based on a directly effective EU law right whose exercise in the UK was not available for long periods because the UK legislation was non-compliant with EU law.
Well, that's inconsistent with what you've just been showing us.
Oh, I didn't mean to say that.
What is the directly effective right to recover tax dating back 30 years or whatever it turns out to be? There isn't one.
But there was no there was a direct, well, if you see it with the advantage of hindsight, we know there was a directly effective EU law right to recover the overpaid output tax under recovered input tax. Direct effect was something only established in the 1970s and 1980s. One reason for Section 121 being drafted in the terms it was, and this claim can be considered purely as a statutory claim under Section 121 of the Finance Act 2008, one of the reasons for Section 121 being expressed in the terms it was that Parliament wanted to make a clean sweep and get things sorted out on a clear and unambiguous basis where there had been all this confusion.
Well, you say that, but I thought what they had to sort out was the fact that there never had been a time limit until they sought to introduce one retrospectively. And so they had to allow people to make claims, give people a fair chance to make claims that had been going back to a time when they had in fact been allowed to, before which they'd sought to cut off with the time limit. Some put that very well.
Yes, but there were, as the court indicated, questions about the status of this right, and Parliament decided to put all these doubts to bed once and for all by taking the date you could make claims back to the 1st of April 1973. I mean, that was one of the questions raised about what was the need for the Finance Act 2008, Section 121, to go back so far. Wouldn't 1st of April 1990 or 1st of April 1989 have been sufficient? But Parliament decided, no, we want to put these matters to bed. We want to put things on a clear, unambiguous legal status as regards the past, and then we don't have to go into the future with one foot in the past all the time. And that's the intention of Parliament.
Right.
The question in this case, and this was very much the point which, my Lord, you made at the start of these proceedings, the much narrower question is whether the first-tier tribunal and the upper tribunal were correct in holding that the difficulties of proving quantification of the claim were sufficient to justify the rejection of the claim as such. Lothian NHS Board had led the best evidence available. Nothing was held back. The first-tier tribunal and upper tribunal held that despite the existence of an under-recovery of input tax, no input tax was recoverable. This was because Lothian could not, in the tribunal's view, fulfill the evidential standards which domestic law required for such a claim. The board argues that as the Court of Session in a house held, there was no such impossibility. In any case, the principle of effectiveness puts a high premium on achieving such quantification, and this was all the stronger when Parliament has enacted special legislation intended to enable these historic claims to be exercised. As the Statement of Facts and Issues sets out in paragraph 3, the issue relates to the quantification of a historic VAT repayment claim whose primary evidence, where the primary evidence is not available. And as Lord Drummond-Young says at paragraph 16, which is at page 2995, the issue is whether it is possible to calculate the amount of that repayment claim with sufficient certainty to permit recovery. So the central principle with which this case is concerned is that domestic procedural and evidential rules must not make the exercise of a directly effective EU law right excessively difficult or virtually impossible. And as I say, this is all the stronger.
Well, what is the directly effective EU right?
The directly effective...
There isn't one to claim input tax from 30 years back.
We would respectfully disagree, and I think for need to looking at this, we do need to go to the Fleming case. We would say no. There is a directly effective EU law right to recover overpaid input tax. Even if there wasn't such a right, we've got the statutory right under Section 121.
Well, that's a different argument, but you're putting at the forefront of your case the principle of effectiveness, which depends on EU law, and for that to kick in at all, you've got to show that there was an EU law right that was being infringed. And you told us earlier that EU law says it's up to the member state to provide alternative ways, and that a time limit of 3 years would be fine.
But the UK did provide alternative ways, and in that case, that is acknowledgement of the right.
No, it isn't. It's just going much more generously than was required by EU law, in that it didn't have any time limit when it could have done. Probably inadvertently, you tell us, but that was the position, that for a long time there was no time limit for claiming back input tax. And then they rather bungled the attempts to introduce one. So it ended up that under UK law, you had the very generous position that you could make claims going back 30 years or whatever it was, but it's not a violation. It's not required by EU law. It's just the way that UK law happened to go, which it didn't for the period 1997 to 2008 or whatever it is. So you're out of court for those, and there's nothing you can do about that.
Until Parliament changed the law.
What are you referring to there?
Well, the Section 121, right?
Yeah, that only goes
yeah,
up
but
to
I'm just,
1997.
that's the earlier claims. I'm saying
Yes.
for the claims for 1997 to 2008, it was 3 years, I think, all along, and that's not something you could say was contrary to EU law.
No, of course it wasn't, because...
So just a bonus for your clients that it turns out that they can claim back longer for the earlier years. It's not an EU law requirement. Isn't that correct?
No, that is not correct.
Right.
Because you had the pre-existing situation where there was no legal obstacle to exercising that right. And the UK sought to introduce a legal obstacle in a way which wasn't consistent with the protection of that right. But to see where that right comes from, we do have to go to the Marks and Spencers and the Fleming case, which is a reason why I should have continued directly on from them to where we'd finished before, rather than trying to go back. So I apologise, my lord, because I have caused that confusion by doing things in the wrong order.
So are we going to Marks and Spencers now?
I think I'd probably rather just finish where I was and then go on to Marks and Spencers, if I may, my lady, or I shall confusing myself doesn't matter. Confusing the court does. I'd finished by referring to, well, yes, as the Court of Session points out at 67, which is page 3025, the fundamental problem in such cases is that primary evidence does not exist owing to the lapse of time. In consequence, the issue was the reasonableness of the available secondary evidence and the assumptions which were applied to it. The first-tier tribunal had rejected the board's fundamental argument, i.e. the use of 2006 to 2007 as a base year and extrapolation back of the rate of VAT recovery to the claim period on 5 grounds at paragraph 196 of the first tier tribunal decision. But as the Court of Session in a House explains at paragraphs 58 to 62, which is at page 3020, these do not answer the board's methodology or address the problem of the absence of contemporary documentation. The Crown has sought to block Lothian NHS Board's right of repayment by means of procedural and evidential requirements, which in most cases it would not be possible to satisfy, and in adopting the same approach, the upper tribunal also erred in law. Now, I said this was a San Giorgio remedy. As the Advocate General said in San Giorgio at part 6, and this is at page 2297 of his opinion, to make the repayment of overpaid charges conditional upon such proof is tantamount to repudiating the right of repayment. And what he referred to as a repudiation of the right of repayment was at page 2299, where he refers to proof of a diabolically high standard. So it's proof of a diabolically high standard, 2299, which is seen as a breach of the effectiveness principle. In Pendragon, at paragraph 51 of the Supreme Court, which is page 1812 at 1838, the Supreme Court criticised the Court of Appeal because it had conducted its analysis by reference to the decision of the first tier tribunal rather than the upper tribunal. That was, however, in a case where the upper tribunal had reversed the decision of the first tier tribunal.
I think that's a minority judgment, isn't it?
It was the afterword of Lord Carnwath,
yes,
with which the other Lords Justices expressed agreement.
I'm rather wondering if I would have agreed with what was said there.
Well, I don't think it concerns us in this case, because that was a case where the upper tribunal had reversed the decision of the first tier tribunal, whereas in this case the upper tribunal simply affirms the decision of the first tier tribunal. I
think looking at it, he's a sole voice.
Yes. So we say the question for the Court of Session in a House was whether the first tier tribunal had erred in law. Or indeed, as my Lord Legate suggested, it might be the way at the start. They simply reached a conclusion of fact which was unappealable. The Court of Session, however, held that first tier tribunal had erred in law, and the error lay both in EU law, disregarding the effectiveness principle, and in UK law, looking for near certainty rather than the balance of probabilities. The right of repayment was made ineffective in practice by imposing a disproportionate evidential burden on the taxpayer. The error arose for the reasons set out by the Inner House at paragraphs 54 to 55, which are on page 3019. As the Inner House observed, having noted the shortcomings in the evidence which had concerned the first-tier tribunal, the tribunal concluded that in the absence of those output figures, it is difficult to confirm the reasonableness of any input tax claim relating to that income. In our opinion, this imposes too high a test on the taxpayer. As a result, the first-tier tribunal denied Lothian Board an effective remedy, so failing to realise the principle ubi jus, ibi remedium. As Lord Drummond-Young says at paragraph 56, 3020, the issue is not the actual amount of the claim, but rather the reasonableness of the amount claimed. The true principle is that estimation impacts on the quantum of the claim, but does not mean that the claim is not evidenced or invalid or is to be completely rejected. So our primary submission is that the Court of Session reached the right result for the right reasons by ensuring that a directly effective EU law right, and I'll return to the point your Lordship, my Lord Legate has raised, that a directly effective EU law right could not be defeated by procedural and evidential requirements which prima facie respected the right of repayment, but in reality nullified it. Nor did the Court of Session develop any novel principle. The evidential standard which the Lothian Board had to meet was relative to the factual and legal context, not absolute by reference to some normative standard. The first-tier tribunal was wrong to despair of quantification. The Court of Session simply applied familiar principles of EU law and the domestic law of evidence to the facts as found by the tribunal to determine the correct legal outcome. And indeed, we could forget EU law altogether and simply say that applying the traditional analytical requirements for what is an error of law and what is an error of fact, the decision of the first-tier tribunal was unreasonable, i.e. inconsistent with the evidence, and not a determination which a tribunal properly directed on the law could reasonably reach. So the board's case is simply this. The difficulties of quantification were not sufficient to justify the rejection of the possibility of quantification as such. If the board cannot win on the facts of this case, no taxpayer will ever prevail where the commissioners challenge a taxpayer's lack of original evidence in a historic claim. If that is the case, then the law passed by Parliament in 2008 is writ in water. That is the outline of our case, and I'll now go to, as promised earlier, go to look at the decision of the European Court of Justice in Marks and Spencer and of the House of Lords in Fleming before going on to section 121. Now, we left the situation to go back to where the story was before we left it. We'd had the decision of Lord Neuberger in University of Sussex. We'd found that the commissioners had misunderstood the law for 12 years at least, in fact considerably longer. There was no time limit for input tax recovery claims made before the 1st of May 1997, but the commissioners were still able to sleep easy in their beds because for claims made after the 1st of May 1997, the 3-year time limit applied. While time limits, and my Lady Rose raised this point earlier, while time limits and procedural rules are to be determined by domestic legislation, those rules must conform to paramount EU law. In particular, they must not give rise to outcomes contrary to the effectiveness principle. And that's Marks and Spencer's, the judgment of the ECJ at para 35, which is on page 2579. And going back to the point raised by my Lord Leggatt, EU law is always going to trench on VAT questions because the common system of VAT is established by directives to which the full force of EU law applied. As set out in paragraph 14 of San Giorgio, the rules that national evidential and procedural requirements the rule is that national evidential and procedural requirements must not render excessively difficult or virtually impossible the exercise of directly effective EU law rights. As the Advocate General said in Marks and Spencer's at para 55, which is on page 2570, the latter condition, namely that the exercise of the rights which the national courts have to uphold may not be rendered impossible in practice. This is the embodiment of the community law principle of effectiveness. Now, the consequence of incompatibility is disapplication. As Lord Walker observed in Fleming at paragraph 24, it is a fundamental principle of the law of the European Union that if national legislation infringes directly enforceable community law rights, the national court is obliged to disapply the offending provision. The issue was brought before the European Court in the Marks and Spencer case, and this case arose out of two claims to recover overpaid output tax under Value Added Tax Act section 80. What was challenged was not the 3-year cap as such, but the absence of any transitional periods. Claim 1 was the vouchers claim, made in October 1996. Between 1991 and 1996, Marks and Spencer's accounted of VAT on gift vouchers by reference to the face value rather than the discounted value of the gift vouchers. This was under UK legislation, which incorrectly transposed the 6th directive, and before the 18th of July 1996, Marks and Spencer made a claim to recover this overpaid output tax. The tax authority agreed to repayment for the last 3 years only, having regard to the 3-year cap. The second claim arose from the UK's 0 rating for food. While bread was 0 rated, cakes were standard rated. From April 1973 to October 1994, Marks and Spencer had sold tea cakes which had been standard rated as cakes. In September 1994, the tax authority agreed that these products should have been classified as bread, not cakes. And on the 17th of August 1995, Marks and Spencer's claimed overpaid output tax going back to 1973. The tax authority disputed the claim both on the basis of unjust enrichment and the 3-year cap. The European Court held that the correct transposition of a directive does not exhaust the effects of the directive. That's the Advocate General at paragraphs 31 and 40, which is on pages 2565 and 2567, and the European Court, the Court of Justice, at paragraphs 27 and 31, which is on page 2573. Both claims gave rise to potential claims to tax paid in breach of EU law. What the court decided was that where a taxpayer had EU law rights, which he could not rely on before national courts, it was incompatible with the effectiveness principle either to shorten an existing limitation period or to introduce a new time limit.
Immediately, isn't that what they decided?
Yes, without providing adequate transitional arrangements.
So if in 1997, instead of providing immediately that there was going to be a 3-year time limit, they given a year to make any retrospective claims, then you wouldn't have there wouldn't be any complaint.
All would have been fine and dandy.
Yeah.
But, there is a big but, at that time we were assuming that recovery of recovery of input tax fell under exactly the same statutory provisions as recovery of overpaid output tax, and that was a mistaken assumption.
Yeah, but if they'd done it for input tax, you couldn't have had any complaint. If they brought in a rule that said, like they did later on, saying that if provided you make your claim back to 1974 in the next year, after that it's only going back 3 years. That would have been fine.
That would have required the tax authority to have become aware that they had been sailing on a false compass for a minimum of 12 years, if not longer. So it is, to some extent, it is hypothesis on hypothesis.
But from your client's point of view, all this is really irrelevant, all this interesting history, because one thing we could be absolutely sure of is that they wouldn't have made a claim anyway during this period. Because they still weren't making claims for the current years.
That is true. But of course, it's this history which has produced the legislative framework within which the claim is made.
Well, I see the time, Ms. Southern. I think we may as well adjourn before we start looking at the judgment in M&S. Can I observe that as you began your submissions at 18 minutes past 2, you're due to complete the submissions for the respondents at 11:48 tomorrow morning. We're used to going at a much brisker pace in this court than we have been today. You're going to have to speed up, I think, because you've only got another hour and a quarter to complete whatever you want to say to us.
That is all the time I need for what I've covered a lot of the ground, but not quite in the order.
Yes. And that's including Mr. Edwards' time as well.
I do remember I once said to Lord Justice Ward asked me how much time I wanted, and he said 2 hours, and I said 2 hours, and he said you've got 20 minutes.
Yes.
Well, I will.
I haven't said that yet, but I'll be saying that at about 11:30
I'm grateful for your indulgence, my lord.
morning. Very well. Well, thank you very much. We'll adjourn now and resume at 10:30 tomorrow.